Another day, another story. Section 196 of IPC using evidence known to be false. Whoever corruptly uses or attempts to use as true or genuine evidence any evidence which he knows to be false or fabricated, shall be punished in the same manner as if he gave or fabricated false evidence. Section 197 of IPC issuing or signing false certificate. Whoever issues or signs any certificate required by law to be given or signed, or relating to any fact of which such certificate is by law admissible in evidence, knowing or believing that such certificate is false in any material point, shall be punished in the same manner as if he gave false evidence. Section 198 of IPC using as true a certificate known to be false. Whoever corruptly uses or attempts to use any such certificate as a true certificate, knowing the same to be false in any material point, shall be punished in the same manner as if he gave false evidence. Section 199 of IPC false statement made in declaration which is by law receivable as evidence. Whoever, in any declaration made or subscribed by him, which declaration any court of justice, or any public servant or other person, is bound or authorized by law to receive as evidence of any fact, makes any statement which is false, and which he either knows or believes to be false or does not believe to be true, touching any point material to the object for which the declaration is made or used, shall be punished in the same manner as if he gave false evidence. Section 1200 of IPC using as true such declaration knowing it to be false. Whoever corruptly uses or attempts to use as true any such declaration, knowing the same to be false in any material point, shall be punished in the same manner as if he gave false evidence. Explanation. A declaration which is inadmissible merely upon the ground of some informality, is a declaration within the meaning of sections 199 and 200. Section 201 of IPC causing disappearance of evidence of offense, or giving false information to screen offender. Whoever, knowing or having reason to believe that an offense has been committed, causes any evidence of the commission of that offense to disappear, with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offense which he knows or believes to be false. If a capital offense, shall, if the offense which he knows or believes to have been committed is punishable with death, be punished with imprisonment of either description for a term which may extend to 7 years, and shall also be liable to fine. If punishable with imprisonment for life, and if the offense is punishable with 1, imprisonment for life, or with imprisonment which may extend to 10 years, shall be punished with imprisonment of either description for a term which may extend to 3 years, and shall also be liable to fine. If punishable with less than 10 years imprisonment, and if the offense is punishable with imprisonment for any term not extending to 10 years, shall be punished with imprisonment of the description provided for the offense, for a term which may extend to 1/4 part of the longest term of the imprisonment provided for the offense, or with fine, or with both. Illustration A. Knowing that B has murdered Z, assists B to hide the body with the intention of screening B from punishment. A is liable to imprisonment of either description for 7 years, and also to fine. Section 202 of IPC intentional omission to give information of offense by person bound to inform. Whoever, knowing or having reason to believe that an offense has been committed, intentionally omits to give any information respecting that offense which he is legally bound to give, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine, or with both. Section 203 of IPC. Giving false information respecting an offense committed. Whoever, knowing or having reason to believe that an offense has been committed, gives any information respecting that offense which he knows or believes to be false, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Explanation. In sections 201 and 202 and in this section the word offense includes any act committed at any place out of 2, India, which, if committed in 2, India, would be punishable under any of the following sections, namely, 302, 304, 382, 392, 393, 394, 395, 396, 397, 398, 399, 402, 435, 436, 449, 450, 457, 458, 459 and 460. Section 204 of IPC Destruction of document to prevent its production as evidence. Whoever secretes or destroys any 3. Document and electronic record, which he may be lawfully compelled to produce as evidence in a court of justice, or in any proceeding lawfully held before a public servant, as such, or obliterates or renders illegible the whole or any part of such 3. Document or electronic record, with the intention of preventing the same from being produced or used as evidence before such court or public servant as aforesaid, or after he shall have been lawfully summoned or required to produce the same for that purpose, shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. Thanks for watching. Please subscribe.